Hello and welcome to HIV Justice Live, where we highlight the work that we and others are doing to advocate for HIV justice in conversation with fellow activists and allies. So it was exactly 5 years ago today that the expert consensus statement on the science of HIV in the context of criminal law was launched at the International AIDS Conference in Amsterdam. And to help me find out how the statement is bringing science to justice, we have some brilliant guests on the show for you. We'll meet HJN Senior Policy Analyst Alison Symington, and hear from Malawian Judge Zione Ntaba, Taiwan activist Fletcher Chu, and SALC lawyer Tambudzai Gonese-Manjonjo about their experience with the statement. And Immaculate B Owomugisha will join us live from the IAS conference in Brisbane. We're streaming live to both Facebook and YouTube, so why not share the link in your favorite social media platform right now? So in today's episode, Bringing Science to Justice, we're going to explore the impact of one of the most important tools in our advocacy toolbox, the expert consensus statement on the science of HIV in the context of criminal law. It was published in the Journal of the International AIDS Society on the same day it was launched at AIDS 2018. And yesterday, at the IAS conference currently taking place in Brisbane, we presented highlights from our latest research on the 5-year impact of the statement. In our new report published today, we take a more detailed look at how the statement's been used, by whom, and what impact it's had on HIV-related laws and policies. Before we meet the report's author, my colleague Alison Symington, let's start with a quick overview of the expert consensus statement itself. What is it? What's in it? Who's behind it? And what hopes did the co-authors have for it?
The expert consensus statement on the science of HIV in the context of criminal law was developed by 20 of the world's leading HIV scientists to address use of HIV science within the criminal justice system, as they were concerned that prosecutions are not always guided by the best available scientific and medical evidence. The statement was originally published on the 25th of July 2018 in the peer-reviewed Journal of the International AIDS Society and first presented at a press conference at the International AIDS Conference 2018 in Amsterdam.
And it was an extraordinary process to bring these 20 people together over a number of times and through much correspondence and email, supported strongly by a secretariat from HIV Justice Worldwide, IAPAC, the International AIDS Society, and UNAIDS in bringing the statement together.
Well, I hope that people will use this consensus statement to review any existing laws and policies to be up to date with what's happening in the science of HIV.
The statement is not just about HIV criminalization laws, because many prosecutions happen not through HIV-specific laws, but through other laws as well. So rather, the statement is an attempt to help courts faced with any of the aspects that incorporate issues around HIV transmission.
The science of HIV today tells us that the risk of HIV exposure from single sexual encounters is low, and in some cases, no risk.
It also includes reviews of the evidence around the harms of HIV. It's obvious that courts view differently grievous bodily harm from assault, from murder, in terms of how they see the outcome of that. And so it's important for courts also to understand the advances that have been made in treating HIV, so that acquiring HIV infection is no longer a death sentence.
A statement like this for me is really necessary, because we found out that not everyone is very well informed where we are in terms of science.
Because HIV is constantly transforming itself, it's quite difficult to say A gave the virus to B rather than that C gave it to both A and B or that B gave it to A. So the statement also includes a section discussing phylogenetics and how important it is for courts to seek expert advice on how to interpret phylogenetic evidence.
I hope that the statement that we've provided becomes a benchmark. And I hope that it will lead to justice.
I think we need to bring our science into justice. And we need to be sure that it is understood and that it has the liberating quality that certainly it has had for all of us.
There is no doubt that this is important knowledge to get out to the broader world. It is our responsibility as people who are immersed in the science to make sure that every sector of the world is aware. And in that way, I believe that people can be treated fairly and equally and justly throughout the world.
So how has the expert consensus statement helped to treat people fairly, equally, and justly? That's what we're going to discuss now with the HIV Justice Network's Senior Policy Analyst, Alison Symington, who joins us from Toronto. Good morning, Alison. Welcome.
Good morning, Edwin. Great to see you and be on air with you today.
Same here. So tell me how you put the report together and what research did you do? Who did you talk to?
Sure. Well, as you know, we've used the statement a lot in our own work over the years, and we've heard anecdotally about it being used in a wide variety of contexts. So to mark the 5th year anniversary, we decided to do a more systematic review. So this included a questionnaire to the authors, a survey that we distributed through our global networks, desk research using a variety of search engines, and some interviews. So the report highlights some of the great examples that we found through that research.
Okay, let's talk about some of those great examples. What were the report's main findings?
Well, overall, we found that the statement has been used in a variety of ways in different parts of the world. This was facilitated by translation. It's been translated into French, Spanish, Russian, German, Czech, and Mandarin. And we found that it's been used in courts, in campaigns, training, media, publications. Basically, the statement assembles the best available science on HIV transmission risk, HIV-related harm, and proof of transmission. And it explains it all in a way that's accessible and appropriate for legal contexts. So it's proven to be an extremely, extremely effective intervention.
So let's hear from someone that was interviewed for the report. Taiwan's Fletcher Chu first heard about the statement when he attended AIDS 2018 in Amsterdam.
It was exciting for us to see a document that specifically aimed to address HIV issue in the context of criminal law. And what's helpful about it was that it put together the studies and it gave a clear idea how to interpret the terminology, like the description of the risk. Because most of the time, the risk of individual action, we use the data, like how much percentage we're looking at the data. But within the document, it categorized in the category including no possibility, negligible possibility, low possibility. And when reading it, there are also like specific scenario within the document that is commonly seen as controversial for judges and law enforcement officers to make decisions such as oral sex or the sex intercourse or other casual touching. And another part that we found it very helpful is the big names of the scientists on the document, like the leading science engaged in the statement, including Nobel Prize winners. So it will be very easy to talk to other people saying that, oh, this is a document from the very well-known institution and very well-known scientists all over the world. So the credibility of the document is also very amazing too.
So we're streaming live to both Facebook and YouTube. Do you have any questions for us? We want to hear from you and let us know about your experience using the statement. You can write your questions or comments underneath either of the live streams. So Alison, let's talk about what was special about the statement. Fletcher mentioned how he really appreciated that the statement provides clarity on HIV transmission risks.
Right. So public health messaging usually talks about risk per sexual activity. And sexual activities are categorized like kissing, oral sex, penetrative sex. It uses the categories of low risk, medium risk, and high risk. So this type of messaging, it makes sense on a population level, and it's useful for HIV prevention type messaging. But the difference is that nothing is high risk when you look at individual encounters, individual cases. And that's what we're looking at in a legal context. You're looking at one or several specific sexual acts.
Right, and in contrast to public health messaging, the expert consensus statement, first of all, uses the more neutral term possibility rather than risk. Framing and language matters, especially in court. And the statement also focuses on the possibility per sexual act, and that this can only be low, negligible, or no possibility of HIV transmission. Far too many of the cases that we know about and included in our global HIV criminalization database involve acts that we know aren't risky, either because condoms were used or the person with HIV was on treatment, or because the acts themselves weren't risky. How could there be transmission when there's no exposure to the virus?
That's right. And realizing that's the main reason the statement was produced. It was to support the defense of people living with HIV who faced criminal charges by using the science. So in the research, we were really pleased to find examples from various parts of the world where the statement had been instrumental to successful defenses, and also where it had been used in strategic litigation challenging problematic laws. So for an example, in Canada in 2022, convictions were overturned in 2 historic non-disclosure cases based on scientific evidence about transmission risk and treatment. In 2019, there was a constitutional challenge in Colombia, and the provision was removed from the criminal code that criminalized exposure and transmission in relation to HIV and hepatitis C. And the expert consensus statement was cited in submissions in that case. Another case we learned about was a recent case from Taiwan, where that expert consensus statement was used to defend a man who'd been charged for HIV exposure.
Yeah, and in this case, a gay man was found guilty in 2019 under Taiwan's very strict HIV criminalization law, even though it was established that only oral sex without ejaculation took place, and the man was on treatment. And he was initially sentenced to 1 year and 5 months in prison. So let's hear again from Fletcher Chu.
The prosecutor, they appealed the case because they thought 1 year and 5 months was a lenient sentence. And it was brought to the High Court as a result. But at the same time, the case was handled by different team of lawyers, which they present the document of expert consensus statement along with UNAIDS publication titled Ending Overly Broad Criminalization of HIV Non-Disclosure, Exposure and Transmission. So when the High Court, they review the documents and they acknowledge within the document, it says it's negligible risk of unprotected oral sex without ejaculation. So the High Court recalled the judgment in 2021, but it's not the end. The prosecutor appealed again to Supreme Court in 2022. And there was a back and forth debate regarding whether these documents, namely the expert consensus statement and also the UNAIDS documents, could be considered valid in the written definition of the reference for criteria of unsafe sexual behavior. But at the end, the High Court gained the acknowledgement from Taiwan AIDS Society about the credibility of the documents, so the case remained acquitted at the end. So that's probably one of the kind of a crazy case we can present because most of the time we know clearly about the risk of the oral sex is really, really negligible, or even we can say zero. But even so, the prosecutor want to appeal again and again.
Can you believe the persistence of that prosecutor? I mean, it really shows how homophobia and HIV-related stigma can really drive prosecutions.
Absolutely. And the statement is a tool that we can use to bring science to counter those forces. So in my research, I found that at least 9 of the co-authors of the statement had been expert witnesses in cases. I spoke about this with Dr. Ben Young, one of the co-authors, and he's given expert evidence in 3 cases in the United States. He explained that medical and scientific experts play an important role in defending people charged in relation to HIV non-disclosure or exposure, because lawyers and judges generally have a poor understanding of HIV. So charges end up being laid when there's really no justification for a prosecution. I found it really interesting that Dr. Young described the statement as a shield against reputational attack during cross-examination in court. He described that to me as something that's very difficult for him when he's called as an expert. But he said with the statement, he's not just presenting his own opinion or based on his own expertise, but he's presenting a consensus opinion of the leading experts from around the world. So that's then indisputable evidence.
Yeah, indisputable. I mean, amazing. We're streaming live to both Facebook and YouTube. Do you have any comments or questions? Put them in the under the live streams on Facebook or YouTube. So far we've talked and heard about HIV transmission risk, or rather possibility, but the statement's also been used to ensure that courts understand the reduced harm of HIV in the context of treatment. So let's hear from Tambudzai Gonese-Manjonjo, who is a lawyer with the Southern African Litigation Centre, or SALC, about a case in Lesotho that ultimately led to a constitutional challenge.
In Lesotho, we got involved because there was a case where a man was convicted of rape. And in terms of the Sexual Offences Act in Lesotho, if you were convicted of rape and you were also found to be, after getting tested, you're also found to have HIV, the law then provided that the sentencing would be aggravated. So in this case, the law seemed to provide that there had to be a mandatory death sentence. So that was really our point of intervention, in the sense that even though it was a rape conviction, the sentencing for rape ought not to differ because of HIV status alone. So part of that case was a constitutional challenge to that section of the Sexual Offences Act. As part of the challenge, we were able to get an expert affidavit from Dr. Linda-Gail Bekker, who is one of the authors of the expert consensus statement. The judge then also looked at, the scientific developments that have happened, the fact that with antiretroviral treatment, it's no longer a death sentence. It's a manageable chronic illness, and the affidavit by the doctor was very clear on that. There was no need, therefore, to have a specific law that targets people with HIV, because it's a chronic illness which can be managed like other chronic illnesses.
Yeah, this case represented a really important victory because the decision recognizes that people living with HIV have the right to life, as all people do. Imposing the death penalty based on a person's HIV positive status alone is really the most extreme form of discrimination possible.
Absolutely. And that's really important about this case. When the other thing that stands out to me about this case is that so many people work together on it. And I think that was, one of the unanticipated but lasting impacts of the expert consensus statement. Efforts came together, like around this case, where we had the HIV Justice Worldwide Coalition, members of human rights organizations, the Lesotho Network of People Living with HIV and AIDS, all came together to work on the case. So through developing the statement, relationships were built between healthcare providers, scientists, lawyers, community, and we're still working together today.
Yeah, indeed. And in addition to bringing clarity to the court, it was hoped that the statement would be useful for advocacy when it came to law reform. Here's what Malawian lawyer Sarai Chizala Tempelhof said at the AIDS 2018 press conference.
In the Global South, the likelihood of inappropriate prosecution and conviction under these laws is high. While women and activists may understand the threat that these laws cause, the consensus statement provides scientific justification and guidance for why, in addition, the application of these laws is so deeply irrational and unjust. The statement is particularly important to support community activists who are fighting against these laws and who often struggle to identify experts at the country level that are willing to stand up and address these issues. I think it's also an example of the science and medical community solidarity with activists. The consensus statement will be a tool for people most affected to empower them in their activism.
So, Alison, how has the statement been used as a tool to empower people living with HIV and our allies in their activism?
Well, Zimbabwe is a perfect example. So in 2018, the statement was introduced at a symposium on HIV and the law, which was hosted by the Zimbabwe National AIDS Council and Zimbabwe Lawyers for Human Rights, with support from the HIV Justice Worldwide Coalition, some human rights organizations, and UN Women. Advocates continued using the statement following that symposium in their law reform advocacy. So they produced a policy brief, information leaflets for parliamentarians and people living with HIV. There was an article in a peer-reviewed journal and a media toolkit. After all of this advocacy, ongoing over several years, it finally happened. In 2022, the Parliament finally repealed Zimbabwe's HIV-specific criminal law.
Yeah, amazing. And by the way, all those publications can be found in the resource library, the Movements Archive, and that's just one part of our HIV Justice Academy. It was a long road, and science was only one piece of the puzzle, but it was an important milestone in the movement to end HIV criminalization. Zimbabwe was the first country on the African continent to enact an HIV-specific criminal law, and around 30 countries across sub-Saharan Africa still have these laws. They really do need to follow Zimbabwe's example. So, Alison, did your research reveal any other ways that the expert consensus statement's been useful?
Yeah, absolutely. We found that it's really been used extensively in education and awareness raising efforts. So people found that explanation of the scientific evidence, it was really clear and accessible the way it had been laid out by the authors. So for example, it's cited as an authoritative source on HIV transmission in academic papers and research reports, including at least 77 published articles and 15 doctoral theses. It's been distributed in training sessions and courses. It informs discussions with policymakers, public health authorities, the media.
Yeah, and the statement's been especially helpful in engaging judges. So let's hear from Zione Ntaba, a judge of the Malawi High Court and also a member of the HIV Justice Network's Global Advisory Panel. And we asked her for her thoughts on the expert consensus statement and whether she herself has found it useful.
When you talk about justice and when you talk about judges, our whole concept is to be impartial and to ensure integrity and not to have any other issues that come into play. And with scientific evidence, one of the things about scientific evidence is that science is supposed to be neutral, like the law. That is going to be it's going to be objective and it's going to give you unbiased assumptions about evidence on it. And that's what we prefer as judges, to have that. And when you have scientific evidence that actually is reliable and is relevant and admissible, in a court case, that would take out the irrationality, that would take out the bias issues, but it would also give you what you basically need in a case, which is the justice of it, because people come to court seeking justice. Now, if scientific evidence is there and available and can be explained in a rational way that intersections with the evidence that's there and intersections with the law, then you will get a judgment that actually does deliver justice. I do a lot of training for key justice responders, so that is judicial officers, prosecutors, investigators, medical officers. So that is one of the statements that we're using when we're doing issues of science and issues of evidence. If you're going to gather evidence, it must meet this kind of parameters. But we've also gone into some stages where we have gone and had meetings with policymakers, parliamentarians, for instance, when we're passing laws to say, look, if you're looking at issues of criminalization, these are the parameters you should be looking at, and that is what the law should be saying. If you can reach that standard, then it means the law will be discriminatory and also be overly broad, and also will criminalize in circumstances which it shouldn't. And lastly, with just the ideology of networking with my fellow judges, we've used it also just for discussions through other ways and means. So that is the way that I've used the consensus statement, yes.
And to learn more about the statement's impact, as well as further information about the statement, you can read our new report, which is now live on the HIV Justice Network website. So for now, thank you, Alison, but please stay with us because I'm hoping that we're able to welcome our next guest live from the IES conference in Brisbane, where I know it's very late at night. She's a Ugandan lawyer and human rights advocate who also sits on the boards of ARASA, ICW East Africa and ICW Global, and somehow she's also found the time to join the HIV Justice Network Supervisory Board. So welcome, Immaculate B Owomugisha. Good evening. How are you?
I'm well, thank you. Good evening, Edwin.
Thanks
so. To see you.
Same here. Thanks so much for joining us on HIV Justice Live. I know how late it is. I know it must be exhausting for you, but because you're working as a rapporteur at the conference, you're covering track D, which is social and behavioral sciences. But I know you've been keeping an eye out for us, looking at how science is impacting laws and policies that impact people living with HIV. So what's the latest from the conference?
Wow, thank you. Hearing from what has come from Alison and where we are now here at the AIDS conference, I must say it has been a place of jubilation for the community of people living with HIV. And why are we jubilating here at the AIDS conference? It's because World AIDS Organization was able to give us very good news. And the good news is on the report that they just published that are indicating that right now, as community of people living with HIV, if your viral load is suppressed, if it is undetectable, then again, to the choice of words, you have zero, and I repeat, zero chances of infecting your sexual partner. So for us, that is the biggest news of this conference, and we've been jubilating, and the community out there is jubilating because for the first time we are going to live free. We are going to live without fear that we are going to infect people living, our partners. And I think this is a great milestone in addressing issues of stigma and discrimination that has always been based on the HIV transmission. So yes, zero chances or zero risk.
For the WHO to state this so clearly is amazing, although it is 15 years since the Swiss statement, which is the first time that was ever said by a group of scientists. But it's so great that it's clear that undetectable means zero possibility. But what I thought was also, what I think is really important too about the WHO document is it also says that people with on treatment with a viral load under 1,000 copies are considered to be suppressed, which means almost zero or a negligible possibility of transmission. You can see in this traffic light. And I think that's really important in the context of point of care access to viral load testing, where the limits of detection are closer to 1,000 copies than the 50 copies that are used in the lab. And this is completely consistent with what the expert consensus statement says. So yes, great jubilation, but I think from our perspective, it's also really useful that it supports the science that's already in the expert consensus statement.
Yeah, definitely it does. And it shows the journey of how HIV science is progressing. And it is directly spoken about that the journey we've come and the journey we are right now is how do we now take on these two great documents to use for policy reform and policy change. And the discussion that came from the scientists and the World Health Organization is, for now, we need to use this to challenge the structures, to challenge the policies that still criminalize HIV. But this report, we also see it taking the conversation beyond even criminal laws, which the scientific report was also showing that now we can use this evidence to guide other policies. And these are policies that include policies in employment, because we've seen we still have issues where people are denied the right to work because of their HIV status. In insurance, people are denied right to partake insurance because of their HIV status. So there is progress from the statement to now the report that is there, that we can take this conversation beyond criminal laws to other laws that continue to affect people living with HIV.
That's right. I know there was this an Act Now symposium on entry, stay and residence restrictions that happened on the Saturday. And I think one of the great things that's happened is that attention has now been paid to the fact that Australia's policy in particular for people living with HIV in terms of migration is unscientific and out of date. And that's now really something that's awareness has been raised. So obviously there's lots of different ways that the WHO policy brief and science in general is helping. But I also wonder what's in the WHO policy brief that's maybe missing. I'm thinking about the work that we do, that Alison leads on around breastfeeding.
Mm-hmm. Yes, so the report, the WHO report, indicates that there are still minimal risk for breastfeeding mothers. And that means that we don't have, we are not yet there when it comes to breastfeeding mothers. But today, in a discussion of 95, we could see also this being distinguishable as to why we still see risks in the breastfeeding mothers. And the reason that is being attached to the risk, it's because you are not, the most mothers after giving birth, chances of continuing into care and retaining into medication based on the circumstances and structures around the women who are breastfeeding likely cause the risk of having their viral load not suppressed as it should. So in that transition from delivery to breastfeeding, there are minimal risks where a mother can transmit HIV to the breastfeeding baby. So, but that calls now for our broader advocacy as activists on how do we work with our mothers, with women to continue adhering and have their viral load suppressed even when they are breastfeeding. So, but I think it is a journey that is also progressing, and if we continue to do our advocacy right, then we will have we'll reach that place where we say that even mothers don't risk transmitting HIV to their babies. And the same conversation goes to the message around U equals to U. And there was a very big discussion on U equals to U. And now we see it clearly fitting into, again, this report of WHO on how we can push our advocacy around undetectable equals to transmission into the community and take it beyond the community, but also use it amongst the policymakers and other actors that influence policy reforms and policy change in our different settings.
Yeah, I'd just like to underline that because I think that's so powerful what you just said, that the risk is because of lack of access to support and care and treatment. And that's such an important gap that we can address. We can change that. And that's really empowering. And I think it should be, lighting a fire under people to really make sure women living with HIV are getting equal access to treatment and care and support. And that we can then say U equals U for breastfeeding and pregnancy as well. And I also noticed in the report, or in the policy brief, that they've stopped differentiating between women in high income countries and women in low income countries. And I think that's a big piece as well in terms of getting the policy to catch up with the science. So I think that's an important thing to note as well. When we're looking at, 14 women in the world that we know of have been criminalized for breastfeeding an infant.
So, Immaculate, I know you're covering lots of things as the rapporteur for the conference. What would you say are your main takeaways?
So in this conference, for me, though it is a scientific conference and it is meant to be purely scientific, I must say there is a great presence of acknowledging the role of community. There is a great presence of discussing the social barriers that hinder access to services, and this includes stigma and discrimination, issues of law reform and policies, the structures at facility level, and all this is recognizing why communities should be at the center and why communities should have a voice to inform the research, but also participate in the research that informs the programming and the treatment that we have. So for me, it is a different space. You feel the science, you feel the community, you feel the social issues that need to be addressed. And I think we are on the right path, because once you bridge science and a community, or research and a community, then we all own what is coming out. And I think it will be easier for the activists and implementers to own this and take it back home and implement it to the best of the communities.
Wow, thank you so much, Immaculate. So stay with us, because now it's the Q&A section, and I'd like to welcome our colleague Sofia Vargas, who joins us from Mérida in Mexico. Buenos dias, good morning. She's been monitoring our social media channels. Sofia, what's been going on Facebook and YouTube?
Thank you, Edwin. Yes, indeed, there has been interesting comments, a lot of support we are seeing from some of the people watching today. We have, for example, a comment from Julian House on how wonderful all this work has been and thanking us for the reporting. Also, we have seen support, for example, for the work done in specific countries, and a general, good spirit on all the work that has been done around HIV transmission. However, we do have one question specifically for one of the people that we saw today. This question is actually addressed to Judge Ntaba, and this person wants to know how the statement has been used in conversations among judges, to which she referred in the video. But sadly, we don't have her with us live now. So I would like to ask, perhaps we can start with Immaculate, so that she speaks a bit on this.
Okay, so thank you. Very good question, how the statement has been used to engage judges. From what the judge spoke about, clearly you can see in Malawi, it is strongly used to engage judges, to train all the justice contributors, and she spoke about the judiciary, she spoke about prosecutors, she spoke about medical workers. But bring the conversation back home also in Uganda, we've used this statement in challenging the HIV criminalization. And one of the authors, Dr. Paula, gave us expert affidavit. Very unfortunate that we didn't win on the Constitutional Court, but at least we put it in court as evidence that they need to make a reference to on how this science has changed and why we should not be having criminal laws per se. And then in the same spirit, we used the same statement to train judges. We had quite a number of judges back home in Uganda that we trained. And again, one of the authors, Paula, was one of our lead facilitators on this. But as it is, training should be a continuous issue. Today you will train this number of judges, the next day they move on. But this is not stopping the conversation. Right now we are seeing in Uganda the public prosecutors, DPP, taking on the conversation. And what is the reference? The reference is they are using the statement, and they are saying, you know, in criminal prosecution where you need to first where HIV is being used as an aggravating factor without evidence of whether indeed the person transmitted HIV to this other complainant. And they are saying, no, can we make a reference to science? And the science they're talking about it is the statement, the consensus statement, and tell court that no, let us use this at the sentencing point, which is the last end of criminal justice. That the person goes through the system and is able to tell that indeed at the end, you transmitted HIV. And if the transmission happened, who was responsible for this transmission? So we continue to see this science being made as a point of reference to engage the judicial and justice actors in influencing policy reforms, but also influencing the criminal cases that continue to be in our courts.
Thank you, Immaculate. Perhaps we want to hear a bit more from Alison.
Yeah, thanks, Sophia, and thanks, Immaculate. I was just going to add that one of the things I found in my research is, you know, the statement's being used in so many different ways, but I think one of the really important pieces around judges is that UNDP has organized regional judges forums where judges from different areas of the world get together to talk about, you know, challenging and interesting new topics. And there have been several of these focused specifically on HIV criminalization. So there was one in Africa where the statement was used quite heavily to engage the judges on the questions around HIV science. And you'll see some examples of those in the report to the person who asked the question, if you're interested in finding out a little bit more about where those sessions take place and how judges are engaged. You know, they really pick the topics that are of interest to them. And also to note that there is a set of guidelines for prosecutors that have been issued at the international level by UNDP. And those guidelines also rely heavily on the expert statement's explanation of the science and really give advice to prosecutors and judicial officers to get at some of what Immaculate was just mentioning about, you know, using the science right from the beginning in deciding whether to lay charges and deciding how to proceed with a prosecution, not waiting till the end of the case and to the sentencing phase, but really that science should be there from day one and giving really concrete information based in, you know, accepted legal principles of how to use the science in prosecution. So there's, you know, different mechanisms through which the science is being translated into judicial contexts and legal contexts.
Thank you, Alison. Thank you for highlighting this. I can see that Amelia Rock thanks you both, Immaculate and Alison. But I wonder if Edwin can add something else to this discussion?
Well, just want to check, are there any more questions, Sophia? Because otherwise, no? Okay, well, I mean, I think Immaculate and Alison actually answered that beautifully. Obviously, Judge Ntaba wasn't with us, but I think you did a great job. I think what I'd like to do is just take a look at what I think we can conclude about the statement at the 5-year mark, because it seems really clear to me that, and to us, particularly when you read the report, that the statement really remains relevant, remains accurate, and is really useful. the newer studies and this new WHO policy brief, they continue to support the science that's in the statement. I think it's great that the statement has gone beyond what it was originally planned to do, which, to be used as defenses and maybe to help with law reform, but it's also been used to educate and to elevate the global conversation about HIV criminalization, as well as the importance of science and evidence-informed laws and policies. One thing that's so clear, hearing also from your experience, Immaculate, at home in Uganda, that ending HIV criminalization can't rely on science alone. But I think it's clear that the statement can help in court cases to limit those unjust prosecutions while we work together to end the HIV-related stigma, the discrimination, and all those structural inequalities that drive HIV criminalization in the first place. So I think we're done. If you want to see this show again or share it with friends and colleagues, it's available on Facebook and on our YouTube channel. And you can find our new report, the statement itself, and other important information about it at hivjustice.net/ECS. And do let us know anytime you have success in using the statement to change laws, policies, even hearts and minds. And you'll find the contact details on the website. And please make sure that everyone in your network knows about the statement, knows that it remains accurate, relevant, and useful. So I'd like to thank Alison Symington, Immaculate B Owomugisha, and Sophia Vargas for joining us live. Thanks to our brilliant director, Nicholas Feustel, to everyone we interviewed, all of the statement's co-authors, and of course to all of you for watching and commenting. See you soon for the next HIV Justice Live.